United Kingdom around 30 years ago, there was a popular song called Love Changes Everything. It featured in the Andrew Lloyd Webber musical Aspects of Love. And you might conduct a Google search to view its lyrics and perhaps even see it performed via YouTube and probably infringe copyright. The song predated the popular internet, but it's quite an appropriate metaphor for what has been a massively transformational technology. The internet has changed almost everything, and intellectual property law constitutes one of the most important aspects of its transformation. Old models are broken, and we're not altogether sure what can replace them. One of the key issues is whether we start to rewrite laws afresh or seek to modify traditional concepts to better meet the needs of our internet society. We start this course by looking at the internet and considering what it does and what forms of conduct it facilitates. You don't need to understand in any degree of technical detail how the internet functions. Our focus is on what it allows its users to achieve, and specifically, what are the implications for aspects of intellectual property law. You need to understand also what agencies play significant roles in relation to what is sometimes referred to as internet governance. Well, what is intellectual property? At one level, it's any output of the human mind. Specifically, and for our purposes, the law recognizes certain forms of output as being specifically deserving of protection. In this course, we'll focus on the role of copyright, patents, and also trademark law, and trademark law within the context of internet domain names. I'll say a few words about each of these elements. Copyright emerged as a legal concept in the 17th and early 18th centuries. Initially, it was linked to notions of censorship. Gutenberg's invention of the printing press in 1439 created the possibility of making multiple copies of documents quickly and cheaply. Previously, books had been handwritten, rare, and very costly documents. The Christian Bible was a focus of controversy surrounding the printing press. Political works were not the cause of controversy, and monarchs or governments became almost paranoid with concerns that works critical of them would achieve widespread dissemination. Perhaps looking at current issues concerned with control of content of the internet, we might see that things have not changed very much. Moving away from notions of censorship, the essence of copyright is that it confers the right on the creator of her work to make or to authorize the making of copies of the work. In many respects, it's a simple system. There are no formalities or procedural requirements. Record some piece of work and you'll get copyright in the recording. No formalities, no procedural requirements, and in contrast to the patent regime, no qualitative requirements. Copyright protects against copying of the work. This raises a number of problems in the internet context. The problem for the user of the work is that every act of use requires the making of a transitory copy of the work. Generally, the answer that's been adopted is for the copyright owner to license the use of the work, often accompanying this permission with a disclaimer for any responsibility for defects in the work. A problem here is that many licenses were drafted in the time when we might have a computer. Today, many of us have multiple computing devices: desktop, laptop, tablet, smartphone, to name but a few possibilities. A standard license may not cover this, but to draw an analogy with an older form of work, I think the suggestion that I would have to buy one copy of a book to read at work, another to read on the train or bus going home, and yet another for my house, it would be met with absolute derision. That's the downside for the user. You're probably familiar with the problems of copyright owners, essentially piracy. With a book, an old-fashioned gramophone record was not easy, or sometimes even possible, for the average user to make a high-quality copy of a work. Think of a photocopier. If you tried to copy a book, the quality would be inferior, and in many cases may well cost more than buying a legitimate copy of the work. Compare that with a music download or upload to the internet. The quality of any copy, and millions of copies may be made, will be perfect. Moving on, the system of domain names is at the core of the internet, although it's the string of numbers and letters known as IP addresses that causes it to function at a technical level. The use of domain names raises a number of intellectual property issues. There are a range of problems. Although the number of internet domains have increased, and we'll consider the new ICANN domain policy, which has seen hundreds of domains established, demand will always exceed supply. In real life, many thousands of people may share the same name. A Google search suggests that there are around 50,000 people called John Smith living in the United Kingdom. They can coexist quite happily, but there can only be one johnsmith.com. Who's entitled to it? Priority tends to be given to people or companies that have trademark rights in the domain. But even here, there may be a good number of people with rights in the same name, either in different countries or for different forms of activity. Tens of thousands of disputes have been brought before dispute resolution bodies set up by organizations such as the World Intellectual Property Organization, or WIPO. And finally, there's the topic of patent law. In many respects, patents offer the strongest form of intellectual property protection. They confer monopoly concerning the use of the technologies specified in the award. So-called software patents have been controversial for a couple of decades, and matters have become even more so with the emergence of smartphones. In the United States today, it's estimated that there are some 50,000 patents, a sixth of all current US patents relating to this form of technology. It's almost impossible to design a smartphone without infringing somebody else's patent. At some time, almost every major player has sued or been sued by every other major player. Often the result is a compromise, whereby each licenses the other party to use their patented technology. A complicating factor, and perhaps less prevalent today than a few years ago, concerns the activity of non-practicing entities, more generally known as patent trolls. These are companies that seek to buy patents, perhaps some other companies that have gone bankrupt, not with any intent to use them in any practical sense themselves, but rather to try to extort license payments from other companies with the claim that their activities infringe on the patent. Two final examples may illustrate the economic value of patents. In 2011, Google bought the ailing mobile phone company Motorola for $12.5 billion. 2 years later, it sold Motorola's manufacturing business to the Chinese computer company Lenovo for $2.9 billion. Was it a financial disaster for Google? I think the answer is no. Motorola failed to market its products well, but it owned some 17,000 patents. Google kept those, and that's the value of them. Second and finally, Microsoft has its own mobile phone operating system. It makes more money from licensing its patents for use on the Android phones than it does from its own operating system. Sometimes I feel we live in a strange world today.